Hello, everyone, and welcome to We Are ACEDS, streaming live on LinkedIn, Twitter, Facebook, and YouTube. My name is Maribel Rivera. I am the VP of Strategy and Community Engagement at ACEDS. Today, I'm excited to be joined by the Honorable Xavier Rodriguez, who is a United States District Court judge for the Western District of Texas. There's a lot there. And he's based in San Antonio. Judge Rodriguez is a renowned authority and frequent speaker on topics relating to e-discovery and information governance. Prior to taking the bench, he was a partner in an international law firm, and he's also the distinguished visiting jurist in residence and adjunct professor of law at St. Mary's University School of Law. Recently, he published an article entitled Artificial Intelligence and the Practice of Law in the Sedona Conference Journal. And he is the upcoming keynote speaker for the December 7th ACEDS Texas Together eDiscovery Day event and the 11th annual UF Law eDiscovery Conference happening in February of 2024. With our members and subscribers showing more and more interest in artificial intelligence and the use of generative AI in legal practice, particularly as it relates to e-discovery, we thought it would be meaningful to speak with Judge Rodriguez and get his perspective and insights given his newly published article. Judge Rodriguez, thank you for joining us today.
Well, thanks for the invitation. Good to see you.
Good to see you as well. I'm excited to get the opportunity. I know Mike couldn't join us, so I was a last minute stand-in, so I hope you don't mind.
No, not at all.
Excellent. First, for anyone who does not know, can you tell us a little bit about your career journey and specifically what has drawn your interest towards issues that involve e-discovery and around information governance?
Yeah. So the journey has been not entirely straight and linear. It took a couple of curves. I always knew I was going to be a lawyer, and so I don't know why. I'm the only one in the family, but I started off studying something really useful as it pertains to technology. My undergraduate major was in medieval history with several classes in the classics. So I've had to teach myself a lot of this along the way, but there is some geekiness into this. My identical twin is the chief technology officer for a hospital chain in Ohio. So there is a DNA trait of tech geek running in our family. But, at first what I thought it was going to be, I thought it was going to be a municipal finance lawyer. That's I got a joint degree with the law school and the LBJ School of Public Affairs at UT. Quickly found out, that requires knowledge of tax and numbers. We're not going there. So became a labor and employment lawyer at what was then known as Fulbright and Jaworski, now known as Norton Rose Fulbright. Did a vast array of just both labor and employment work and general litigation of all types. So was there for a good 18 years or so. Unexpectedly got appointed to the Texas Supreme Court in 2021, a few days right before 9/11. That was an odd time to start entering into public service. Did that stint for about a year and a half, and then was nominated to this bench in 2003. So it's been 20 years on this bench now. My origins, I guess, if you want to call it that, when e-discovery is, back in the old Fulbright days, I had a case. And long story short, the client was relying on an email that supposedly was sent from the other side. Got to remember, this is 2001-ish, 2002. Relying on an email that supposedly existed out there about why they were only going to have a certain number of participants in this clinical trial. Turned out that was not enough participants and to get FDA approval. And so their client sued them. I'm defending. We searched high and low for that email and never found it. And I quickly realized this is going to be on to something. and there's got to be a better way. And I've had that interest ever since.
Excellent. Is there any, just thinking outside the box here, medieval history? Have you been able to use that in practice at all?
So you never know when history comes into play. You know, I went to Harvard, and even Harvard now has to market its history program. And so they asked me to write a short little couple of paragraphs to publicize in the history website over there to market to students why they should study history. And in a nutshell, I basically said, unbeknownst to me at the time, the study of history, at least where I went and many programs, it involves a voluminous amount of reading. Sometimes, not in the original for me. I didn't know French or Latin, but it required a voluminous amount of reading and writing and analytical skills. And you're looking at both, political history, social history, economic history, and so without realizing at the time that it was actually really good preparation for what was going to be my career on the bench. I never thought I was going to be a judge, but it was excellent training to be a lawyer and a judge. And as we're becoming more technical and technology is going to play a greater and greater role, it's constantly evolving and changing. But one thing or two things remain the same: the ability to communicate both well in writing and verbally remain the same. And so skill sets like social studies, geography, history, political science, the liberal arts still remain highly relevant. And I think too many students are ignoring that.
Excellent. Well, that's great advice for the students out there. Thank you. Let's talk a little bit about your paper. It is a lengthy paper. So what prompted you? I know you've been involved in Sedona Conference for many years. What prompted you to write such a lengthy paper on AI?
Yeah, so the origins of that paper, I got asked by the State Bar of Texas president to be on an AI task force that she was establishing here in Texas. And so, I do a lot of work in e-discovery. I teach e-discovery. I try to monitor developments as best I can. And so when I first got approached about this AI task force, I heard of AI. There have been passing references and past CLE programs. I keep a running list of notes to myself and monitoring things. And I actually saw a note that I wrote to myself, dated in 2018. And so when I was going back through my old notes, I thought, oh, wow, well, it was on my radar. I obviously took note of it, but I frankly did not realize, and I think a lot of people are in the same boat, about how fast this was going to take off. I think that surprised a lot of us. And so I get asked to be on this task force. I immediately start digging back to my old notes and then just immersing myself into everything and anything I could read for the last 2 years, basically, to try to just refresh myself on where we're at, what were the origins, what are the current developments, and where possibly are issues of law that state bars need to be looking at, ethics commissions, state Supreme Courts. And before I knew it, 40 plus pages later, with, 120 footnotes for your nighttime reading, there it is.
Oh, and I've been skimming through it. So there are that many pages and footnotes. So in the article, you write that you assume that policymakers and lawmakers will, quote, will in the future enact regulatory or statutory requirements, end quote, that will govern artificial intelligence. What, in your view, are the top concerns that require regulation of AI and the content of as it relates to e-discovery?
Well, there's a number. Just, especially for generative AI tools like ChatGPT and others out there that are coming out, there's a big question about whether or not This is let's put us all on the same page here. The way all these AI tools have been developed, the generative AI tools, there's been huge bodies of works that have been acquired from the internet and from other sources in building these AI tools. And so the first big question is going to be, in the acquisition of all this data, materials, books, articles, was the acquisition and downloading into these AI tools copyright infringement? So the courts and Congress are going to perhaps need to settle that question, because it's a question pending out there. There's some already lawsuits in progress here, and so far they have not been successful in challenging this as copyright infringement, but it's still a concern that's out there that needs to be addressed. So that's number one. Let's assume that these challenges are going to be unsuccessful, and these companies won't have to worry about royalty rights that they have to divvy out. Then the question that I think these regulatory bodies are going to need to be looking at, and a number of commissions have already been established, though Biden White House announced a whole bunch of new initiatives as of late. This is all like within the last month or two. Yeah. And we're going to need to figure out what level, if any, transparency these AI providers are going to need to provide to the public at large and to their specific clients in particular, because there's an issue of transparency that I think everybody is concerned about. These AI tools, how have they been developed? How have they been trained? I'm sure most of the AI providers are going to say that this is all proprietary, and they're not going to want to disclose that. So we're going to have a little back and forth, I'm sure, between these AI providers and the regulatory bodies as to what the sweet spot may or may not be, as to how much disclosure needs to be given about how these things were trained. So that's going to be the second big part. Along with that issue is the issue of bias that's being raised out there. Yes. So the way these AI tools have been developed, some have been developed that unintentionally end up seeping bias into the results. So, for example, there was a system called COMPASS, COMPASS, and it originally was designed for something else, but some states had started using it to make bail decisions, and the way the program was trained, it had embedded into it addresses, for example. And at first blush, you think, well, how is that discriminatory? But when considering bail decisions, all of a sudden, especially in the United States, addresses have a correlation with race. And so the COMPASS system was leading to some absurd results, that white defendants with lesser criminal history with greater criminal history were being afforded greater bond opportunities than African-American defendants with lesser criminal history backgrounds. And so there's going to be a back and forth on, okay, how were these AI tools developed? What were the parameters used to train to develop the algorithm? And so those are the major regulatory issues for now. There's going to be, I'm sure, other issues developing as these programs get used greater and greater.
I agree. You also write that there's a great potential for AI to reduce legal costs, which we know in e-discovery is always the top question, is how does this reduce not just the risk, but the costs that are associated with it? What do you see as some of the ways that AI can reduce legal costs?
So in the paper, I don't focus a lot on e-discovery just because that's emerging. So
Mhm.
let's talk about just legal cost in general right now and various AI tools. So there's been a great concern about access to justice, and that there's a lot of individuals who can't afford a lawyer, or have decided that given the cost of a lawyer, they'd just rather wing it on their own. And so a number of pro bono providers have been trying to wrestle with how do we stretch our limited resources to reach the many who need us. AI potentially has a huge effect there. Nonprofit providers could use AI tools to enhance communication between their clients and themselves, making the limited number of bodies there multiply in some sense. There's going to be a question about, well, what should be the communications that take place on these AI tool platforms? How much legal advice, if any, should be generated by the chatbot, and who's going to monitor the chatbots for accuracy? Whole bunch of issues start coming up into play here. But if we can address them appropriately, bringing down the legal cost and making access to justice easier for a whole bunch of individuals who don't have access to lawyers currently, could be an answer. That's in the no, pro bono world. But now for rank and file law firms, we have an opportunity, I think, here to reduce the cost to the client and enhance communications. By the way, one of the major areas where lawyers always get grievances is the inability to keep the client informed and adequately communicate with the client. That's the biggest source of grievance complaints. And so AI chatbots could help with that. We could start now, automating the responses to the clients, letting them know what the status of their matter is. That could be one way we reduce cost. The ChatGPT prompts is going to be another way where we possibly can reduce cost. So if anybody hasn't played around with ChatGPT, I encourage you to go onto the free site. It's got limited capabilities, but and you don't want to use this for actual practice at all. You're going to want to use the commercial versions that you have to pay for. But playing around on the free version will give you a sense of what these things can and cannot do. But in terms of reducing cost, Westlaw Precision and Lexis has now got very unique platforms, and they're not alone. And I'm not promoting any specific products. I'm just giving examples of what just is out there. But just as an example, Westlaw Precision, on one half of your screen, you type a prompt just like you would do a ChatGPT prompt, and the program starts generating the response. And on the other half of the screen, Westlaw Precision starts providing you with the 3 to 5 cases or statutes that the algorithm used in developing its response. And you're able to click on those cases and sites, adequately satisfy yourself that the prompt is correct. And then with a push of another button, it automatically goes to your Word and populates the document as a motion or a response or a brief or whatever you have. Just imagine the cost savings, going back to cost savings here, just how much money we might have saved in research. And now, I want to caution everybody, these are drafts, right? They're never final products that go out unreviewed. But even as a draft, the cost savings are enormous here. Other potential cost savings, marketing. If you're a small solo or a small firm and can't afford a marketing department, I did this on my own on the free platform with ChatGPT. I don't have to market myself, right? But I said, how do I improve my LinkedIn platform. And it gave me a whole slew of ideas of how I can improve my LinkedIn account. I didn't do it because I don't care about marketing, but it's just an example of just how creative one can be in reducing your cost and then hopefully passing on those reductions to your client.
No, those are excellent examples. And I mean, even LinkedIn now has built in some AI to help you improve specific areas of your LinkedIn profile. So that shows you how far it's going. Do you, just a little off some of these questions, but do you think that some of us, our lawyers that are coming up, right, our law students, should learn a little bit more about prompt engineering, how to create those prompts correctly? Because just writing something doesn't necessarily give you the results that you need.
Yeah. So the current state of generative AI tools requires a prompt. And so for those who haven't played around with these programs yet, a prompt is basically just a query, just like you would do in Google or whatever your internet browser may be. And so, but it takes no matter what you put in, it will give you some kind of response. Now, how to get a better response requires what they call prompt engineers. And you don't have to be a prompt engineer. What's meant by that is each of these tools have the ability, if you rephrase your question adequately, you get a better response. So, for example, you could give a query into your generative AI tool saying, act as a law clerk to a U.S. district judge. You have been assigned an employment discrimination case where the plaintiff is alleging race discrimination. Please provide a summary to your judge with regard to the current state of law. So there, what you're doing is you're providing your into your prompt roles, and you can change the roles if you want to. That's why I encourage everybody, just play around with these things. People joke around. You can say, hey, act as a pirate, and all of a sudden now the tone will change. Or you can say, I want a more informal version of this response that I can provide to the client as a status update. And so depending on the persona you give, the role you want the prompt to take in account, you could give date parameters into those things. So hop up around the internet. There's a whole bunch of already good guidance as to prompt queries, and most of the commercial paid GPT platforms now also have advice about how to properly draft a prompt. Now, you were talking about what do we need to have young lawyers and law students trained.
Yeah.
From now they'll need to know how to do prompt engineering. We'll see how long that might need to be the case. A lot of these tools are now allowing just for an oral recitation. So you just talk to the AI tool. So are we going to need prompt engineers in another 6 months, a year, 2 years? I'm not sure. Some people think that's prompt engineering is just a temporary state of affairs. We'll see whether that turns out to be the case or not.
So I want to touch a little bit more on students, right? On law students and new and young lawyers. What are your thoughts on how we should be educating them, right? Not just on AI, but technology competence questions. That seems to be, I mean, I've seen you on many presentations, and I've seen other presentations, but what are those things that they should be aware of and engage themselves in? And some law schools don't teach them the technology pieces that they need to understand. So what should they be doing?
Yeah, that's a tough one. So there's a few of us out there, right? The University of Florida, and there's me, and there's maybe, I guess, about 40, I don't know, I haven't kept track of how many law schools out there have, and they're generally adjuncts. Bill Hamilton at Florida is unique in that he's actually part of the permanent faculty there. But there's a number of us teaching e-discovery courses. That's a very good start, but there's not enough of us doing that. And then we all do it slightly different. Some of us introduce technology tools in addition to talking about what the law piece is. And so different vendors have been kind enough to lend me over the years their product. And I basically have my law students acting as first year, second year associates. I give them requests for production for which they have to find the number of responsive hits, do privilege analysis. And so I'm not, of course, making them an expert in the tool, given the limited number of time that we have in the class and their class hours, but I'm trying to give them exposure. And I try to be platform agnostic because we just don't know what platforms they're going to use when they get out there to their respective law firms or places of business. But, I think that's a necessary step. I wish more schools were doing that. But, and it's funny you asked me this question, I'm wrestling with how do I redevelop my e-discovery course coming in the future. I don't think we can, in light of generative AI and where I think this is all going to be headed, I might have to retool my class. And so I think we need to have a lot more emphasis on privacy, both state law privacy and global privacy statutes, and how that's going to interact with e-discovery and data retention. And then, of course, then there's cybersecurity concerns that I think we need to be teaching to these students. So there's like a merger of all three of these things happening. And so I'm trying to figure out, and St. Mary's has asked me to try to develop a course in technology. If anybody out there wants to help me, I'm open to help. And so I've got to give some thought to what that new class might look like, because you're absolutely right. That is the future for these law students and for new associates.
Which is great, because I think a lot of them don't think they need that technology competence. Even existing lawyers don't think they need to have that. So,
yeah, that's so misplaced. So going back to the AI and the ChatGPT, a handful of lawyers are getting in trouble with this, right? They're taking what should be a tool, acting like it's final product, and then just filing in the courthouse, basically unchecked, and then they get caught with the problem. And I think it's a matter of educating lawyers about what technology can and cannot do, what are the pros, the cons, and the limitations. Overall, I'm a technology enthusiast, so I think too many courts are emphasizing the problems and the limitations, and that's, I think, a mistake. Some of these courts are sort of giving what I think is a technology, anti-technology sentiment in some of these orders. That's not the direction we should be going. While I'm on a rant, I'm so disappointed sometimes in some of these orders. I keep on reflecting, the medical association, the American Medical Association, doctors in the United States have been adopting AI tools already in their practices for years now. AI tools now are, in some instances, doing a better job of early cancer detection than the traditional radiologist. If we can find a way to make all this work safely and efficiently in the medical field, where people's lives are truly at risk, why can't we do this in the legal industry? We are just so generally overly cautious and ready to say no. That's our instinct. We want to say no but that is not the future. And we've got to get to, okay, how do we do this? How do we do this protecting client confidentiality? How do we do this ensuring transparency? How do we do this ensuring that we're not using tools that may be biased? But there's answers to this, and the answer isn't no.
Excellent. So I've got a couple more questions. I know we're tight on time and I don't want to take too much more of your time, but what do you want readers to take away from this paper? Just based on this conversation, I read the paper. I thought it was important to read, being in legal industry and in e-discovery. But what do you want them to take away from it?
So the takeaway, I think, is AI is being embedded in numerous aspects of society and business. So we as lawyers need to understand what's already taking place. We need to understand, and I make some passing references to the various laws and proposed statutes affecting all aspects of our business. Employment law, for example, and using AI tools in the hiring or promotion of employees. And so we all need to have an understanding of just how our clients are using this technology and what are the potential risks that may be affected, what are the new laws that are being implemented. And so the big takeaway is head in the sand will not work.
Excellent. You've got a few speaking engagements coming up. I mentioned some of them earlier on. Where can people find you? What are you going to be talking about that should excite them, and why they should be there?
So next week or so, I'm in Austin. So hope to see all my Texas friends there. We'll have a nice little discussion about. I'm going to try to focus a little more on e-discovery there, where I think I see this headed. Just a preview. Where I think I see AI tools headed is they're going to be embedded in large businesses. And so we're going to see now, perhaps not yet, we're not there yet, but we're going to see large law firms, instead of doing the traditional, who are the custodians, interview them, find out where the information is residing. We're going to have ChatGPT prompts that we're just going to ask, we need information regarding the following matter, and please identify these for us. That's not too far in the future, I don't think. Then we're already seeing e-discovery tools currently that claim that they can use AI now to find responsive documents, tag them, tag for privilege. I think there's going to need to be some little more proof to the effectiveness of some of those, but we're already seeing that technology being adopted into e-discovery tools. And so I think e-discovery of the future is going to be still with lawyers. We're going to still need lawyers to do the quality review, but that's sort of the direction we're headed. And so that'll be a lot of my Austin focus. And then for the University of Florida program, I think I'm going to try to talk about the convergence of e-discovery, privacy, and cybersecurity, and our role as lawyers in that.
Excellent. Will we be able to see you at Legal Week as well?
Haven't gotten an invitation, but yeah.
All right, well, we'll have to try and make that happen. Thank you so much for chatting with me today and taking time out of your schedule. It was such a pleasure. And for everyone else, thank you for joining us on We Are ACEDS live stream. You can find any of our previous interviews on YouTube channel, and you can tune in on LinkedIn, Twitter, Facebook. We've got We Are ACEDS, our Case of the Week featuring Kelly Twigger, our e-discovery Leaders Live featuring George Sosha, and our Data Unmasked with various different members of Haystack ID. Thank you again for joining us, Judge Rodriguez. It was absolute pleasure. And I will see you in Florida.
Yes.
Excellent.